Trusted Inhabitants of the Town of Sutton. In accordance with the provisions of Mass General Law, Chapter 40A, Section 11, the Zoning Board of Appeals will hold a public hearing at the Sutton Town Hall on July 12, 2018, at 7:30 PM on the petition of Alicia Reed. The petitioner requests a special permit, Section 7A2, as it pertains to 1C 2D of the town zoning bylaws for the construction of a front farmer's porch. The property that is the subject of this petition is located at 143 Dudley Road, as shown on Assessor's Map Number 5, parcel number 154. The property is located in the residential rural zoning district. A copy of the petition may be inspected during normal office hours in the town clerk's office located in the town hall. Any person interested or wishing to be heard in this variance petition should appear at the time and place designated. Daniel Petrelli, Board of Appeals Clerk. Welcome this evening, gentlemen. If you could just state your name for the record.
I'm Michael Mason, President of April Building and Renovations, Inc.
Theodore Landman, employee of April Builders Renovations, Inc.
All right. If you could tell us a little bit about your request this evening.
It's to construct a farmer's porch, which is, it comes out 4 feet from the existing house, because there's a 2-foot overhang. So it would be a 6-foot by 32-foot farmer's porch in the front of the colonial.
The footprint only exceeds 4 feet past the front of the house due to the 2-foot cantilever.
Any questions from the board yet?
Just to make sure, currently your front setback is 37.8, and this would put it to 33.8, is that right? Okay.
Mike, any questions?
When was this lot created, do we know? Does it say what year? Curious. Because I think one of the things that we said is to just be mindful for lots that were created after zoning doing variances, so just curious of the year of the,
I believe it's 1987
so that
was when the house was built, if that's what
Yeah.
your question is.
So why would have they, maybe, because, like, why, if it was, so back in then, when it was built, was 50 feet the zoning? You had to be 50 in the front? Or is this got?
Yep.
You know what I'm getting at, so they barely need a variance, so this lot was created after zoning, and they had to have 50 feet of frontage. That's just a question, just to understand it.
Yes, that's what we're aware of, that the zoning laws changed post the house was built. But to be specific, I don't know that as a fact.
Yeah, I don't think that had anything to do with setbacks, it just had to do with
Yeah.
buildability, but I could
When
be
did
wrong.
setbacks become the law?
I think it's
Zoning,
always
right?
pretty much been 50,
The
50,
50.
and 20.
been 50, I think.
In the zoning, so if the lot was created in the 80s, that was prior to zoning, so that means those setbacks. Did this get a variance already? Do you know, is there any prior variances on the property?
No,
I'm unaware.
Well, right here, Mike, it says this, well,
Oh, I'm
it
just
still
curious
had
of
a
those things.
50-foot
It doesn't-
setback. Those are
Right,
the
but this house
zoning-
never met zoning is what
Right,
it's.
yeah, that's
all
what I was just
trying
gonna
to
say. It's
understand. It's
still-
just,
It never met it in the beginning when it was built.
yeah, I was just curious how,
It could have been like Highland View, where the setbacks were 40,
Oh, because of it was,
and then when zoning
Something, yeah.
changed,
right, but he's 37.8 to the front of the house, or is that to the front of the new porch? That looks like to the house.
To the house.
How's
Right,
that?
so you're gonna be
33.8.
33.8. So I just, even if it was 40, it didn't meet.
yeah, it's still,
Not trying to be argumentative, it doesn't affect what, I think it's fine to
Yeah.
have the porch. I mean, it's
Yeah.
it's
Mr.
nice little
McGovern, when
fun-
I actually went physically and taped it off, it's 51 to the street.
To the street?
However, yes,
Right.
right
Maybe they changed
now,
lot
it
lines
is
somewhere along, I don't know.
51 to the street. However, when we had the survey done, of course, that much of it is evidently, I guess, not their property.
it's right away.
yeah, the edge of the take.
Come right away.
Maybe at some
Oh,
point
Maybe
they,
it got
changed
staked
it.
out wrong, I
Yeah.
don't know.
See, there's always a circumstance, like I said,
Yes.
I think when you got a fixed house, to ask just for a front porch isn't unreasonable at all, I just,
Yeah.
as we start to understand more.
that's all right. Any other questions? Is there anyone here who would like to speak for or against this petition? I see none. I don't see much need for a site visit,
No, I'm good.
unless anybody else
Yeah,
does.
fixed house. Just what did John say when we do these, so they don't have to do the as-built, right? We want to do
Right.
our approval a
As
certain
long
way,
as
because
it's
when you have a
fixed
fixed
to
house,
the-
if
Right.
we say the dimension off the house, then you don't have to do an as-built.
Excellent, thank you.
Right,
It'll just
yeah,
be a little
save you a little bit
savings.
of money.
Thank you.
Thank you.
Well, because it's a fixed house and we're letting you have a
Yeah.
front porch, so the
I-
building inspector happened to be at the last meeting and just made us aware of it again. Sometimes you forget all the little
Very good,
things.
that just saved our client $400, I appreciate that.
So we'll make sure that as long as you adhere to those measurements you have on the plan, John can just verify when he does his inspections that the porch
Absolutely.
is.
Mhm.
So just
You
be
have a
mindful.
copy of the plans?
You should show the dimensions, right?
Yeah.
So
Yep.
just make sure that.
Yep.
I think it's 4 feet.
Of course.
Sorry?
4 feet you're asking for?
Yeah, it
Plus
is,
or minus,
yes.
we could
It's
say,
gonna
a
end-
porch 4 feet plus or minus.
Right,
That way if it's 4'1",
right.
That's
There's
the
a
only,
2-foot overhang, so the actual deck
Yeah.
will end up being 6 feet off the house, but 2 feet of it's already there above the house.
4
So-
feet plus or minus 1 inch.
sounds good to me.
We'll give you a couple inches.
Thank you.
All right, I'll entertain a motion to close the hearing.
Make a motion to close the hearing?
Second that.
Second.
All those in favor?
Aye.
We'll do a work session this evening, and Lynn will let you know, unless you want to stick around and watch.
Thank you.
Thank you very much, gentlemen, ladies and gentlemen.
Thank you.
I would wait, I mean, if you wanna bring it in, it's gonna take a while,
Oh, no, oh, okay. I just want, they're out of the country and I just wanted to give them to me. So, okay, I'll let them know that.
Call me tomorrow.
I will. Thank you for your help.
To all interested inhabitants of the town of Sutton, in accordance with the provisions of Mass General Law, Chapter 48, Section 11, the Zoning Board of Appeals will hold a public hearing at the Sutton Town Hall on July 12, 2018, at 7:35 PM on the petition of Ronald and Diane Lalone, trustees of the Lalone Living Trust. Petitioners request variance relief for lot area and lot frontage needed for the construction of a single-family home. The property that is the subject of this petition is located at 45 Stone School Road and is shown on Assessors Map number 11 as parcel number 72. The property is located in the residential rural zoning district. A copy of the petition may be inspected during normal office hours in the town clerk's office located in the town hall. Any person interested or wishing to be heard on this variance petition should appear at the time and place designated. Daniel Petrelli, Board of Appeals Clerk. Welcome.
Thank you, Mr. Chairman. Mark Wickstrom. I'm an attorney here in the Blackstone Valley. I have an office in Uxbridge, practicing with my 2 brothers and my sister for over 20 years. And I'm glad to be in Sutton today. As you can see from the petition, this is sort of the last lonely lot that is not built upon in a sea of otherwise developed lots for single-family residences. Um, The history of the lot is somewhat important for tonight. As you can see from the 1987 plan that we attached, the Lalondes at that time owned this property, and at that time, the Sutton zoning bylaws allowed for lots of this size to be created due to the fact that town water and sewer was being made available along those streets. That allowed for the development of the neighborhood, which is entered on Fox Run Road, which is the corner of Stone School Road. This property is this corner of Stone School Road and Fox Run Road. And as you can see, I attached a copy of the assessor's map showing the neighborhood, that all of the lots that have those single-family houses in the neighborhood of Dudley Lane and Okemo Ridge Road and Wachusett Drive and Attitash Ave all have similar-sized lots, actually probably smaller lots than the one we're talking about tonight. There was at some point after the lot was created by this plan, the Sutton bylaws changed to end that exception to the acreage rule, which allowed for the development of that neighborhood where water and sewer is available. And the Lalondes, frankly, didn't know about it. They had already sold the lot, which is shown on the 1987 plan as Lot F1, and the people who bought that lot had built a house on it. And frankly, they were making this lot sort of a part of their portfolio for retirement. As the years went on, they kept the lot and thinking that someday they would be able to supplement their retirement. And they, in 1999, unfortunately, Mrs. Lalonde suffered a brain aneurysm, which made her disabled and unable to work anymore. So the family, Mr. Lalonde continued to work, but they continued to think in the back of their minds that this lot would be helpful to them in their retirement. Mr. Lalonde's now 69 years old, and Mrs. Lalonde is 65 years old. They recently, back in the spring, back in the late winter, spring, they put the lot up for sale. They got a good offer on it, and they took it. And only at that time did they learn, when the builder went to go explore whether or not it was buildable, did they learn that their lot was not buildable. Over the course of the years, from the time of the creation of the lot to now, they've been paying taxes on a buildable lot. For instance, in 2017, they paid, I believe it was valued at $105,000, and they paid taxes on $103,700, and they paid taxes on that to the tune of $1,700.11. So that's just an illustration of the taxes they've been paying over the previous 20 years. And they also paid the Wilkinson Water District a little kicker of $47.70, even though they didn't have water to any house that was there. So that all that is just by illustration, talking about the factors that we are here tonight to try to meet in order for the board to use its discretion and help the Lalondes out to be able to sell this lot and make it a valuable lot for somebody to build a single-family house. And the reason I went through the family history is to talk about the hardship that they would suffer if the board were not willing to use its discretion. as you can see, the other factor that the board has to address is the hardship related to the topography of the land. And our argument is that, yes, when you look at the totality of the neighborhood, this entire neighborhood has been built out residentially. There's really no good use for this property other than as a single-family lot. The water and sewer, I understand, is available for hookup, so that would add to the town's users that would defray the expenses of the water and sewer usage in the Wilkinson Water District and the town sewer lines. So they'd be adding, so it wouldn't be a detriment at all to the neighborhood to add one more lot. They'd probably, by a small fraction anyway, defray the costs of the water and sewer division by adding their hookup fee and also being users as a single-family dwelling. So the rest of my presentation I made in my writing. I think we definitely meet the standard of that there's no detriment to the public good in granting this variance. It fits, the request fits nicely in the neighborhood. And that also, that you're not derogating from the intent and purpose of the zoning bylaw by granting this petition. Because this really is the only lot that this argument could be made for, at least in this part of town. From my view of the GIS maps, it looks like this is the last one. So there's no precedent that the board would be setting by granting this variance, and certainly would be much appreciated by the Lalondes.
Okay. On your, kind of on the history of the law here that you provided us, it says in 2018, Town Council said that the grandfathered protection had ran out. Where did you get that information as far as the Town Council?
There was an email chain that was going between my brother at the time, who was asking the town planning office to consult with Town Council to see if they could come to some solution. I'm not entirely sure if I agree with that opinion of Town Council, but and
sure you
certainly when you look at it, when you look at a lot that's grandfathered under Massachusetts law, you'd take a quick glance at this and say, this is definitely grandfathered. But then when you go to the nitty-gritty of Section 40A, of Chapter 40A, Section 6, you start to, and all the decisions, and there's thousands of decisions that interpret, definitely in the high hundreds that interpret 40A, Section 6. And it would seem that it would be debatable, but we'd rather come before you, ask you to use your discretion rather than get in a fight about it, frankly.
Okay.
So just to clarify, it was buildable, it became unbuildable, it's still unbuildable per the town council.
Yes.
Okay.
Unless there was a variance, right?
And the two lots were together. They were owned together until 1992?
It was one part, yeah, it was one parcel, correct.
Until 92.
Right.
So if we granted a variance, it still looks like the lot would be non-conforming because of the 50-foot setback requirement, is that correct?
They intend on meeting all the setbacks. It would just be for frontage and acreage. the sketch might not be to scale.
I see 47,
The sketch is definitely not to scale, but they intend on meeting all setbacks and all the other rules and regs of the town of Sutton, other than the acreage and frontage.
Probably says it somewhere in here, just so it's cut. So right now, this lot doesn't meet the requirement because of lot frontage and
Back
size.
in the eighties, the town allowed parcels that had less area frontage, but had sewer and water, the ability to be considered legal. In 1998, they switched it. They got rid of that and it went back to the standard just under 200 or 2 acres, 80,000 square feet.
So when this got
250
created, it
front.
met zoning.
And then it lost its grandfathered status. They had 5 years.
So at one point, somebody thought they had 2 lots, paid the taxes on
Somebody
it.
bought a lot.
So this is super unique, and I understand these laws because I've seen them many, many times and how they work. And it can be tough.
Right.
Because that's the law.
That's right.
But it's good to understand everything, because remember, we're
Yes.
just
Yep.
people.
Sure, yeah, no,
And these get complicated, so I've probably dealt with it a few more times. I think you've seen it before.
Yeah.
So in layman's terms, I believe, so when you have 2 pieces of land that touch each other, and they were under common ownership at some point, there was a 5-year period that you could have done something, sold it, taken in, not had it in common ownership. They just missed it. They didn't, it's not broadcasted. I could see it's a tricky law. I almost think it's not fair.
Yeah.
Every time I'm faced with it personally, or as this board, I always struggle with it because it's not fair, right?
Right.
I'm sure
Yeah.
that you two sit there.
No.
So help me to say yes.
Sure.
Because we can't break the laws.
right, yes. Well,
I surely
I think under the.
agree with everything else that you said.
So town council's opinion was strictly an as-of-right opinion, that they don't have but they didn't say that a variance was not allowable. They just said that they couldn't build as of right. So what we're asking for today is a variance based on the factors that we've laid out in the petition, that would give them the relief from the frontage and acreage
So,
to make that a buildable
You
lot.
talked about the hundreds of cases. Is there any case law that boards have ruled in the favor of this not knowing? Because
Yeah.
it's a rule that has affected a lot of different people, more than you
Right.
guys, trust me.
Yeah.
This has come up.
Well, we're not making the 48.
It's not the first
We're not
time.
making the 48, Section 6. I put that in just to sort of show why they ended up in this predicament.
Mhm.
But we're arguing under 48, Section 10, that we'd prefer the board to use.
See, I bet this
discretion.
isn't a
Yeah.
board that wants to argue, so I'm asking you for some legal help.
Sure, yep, yeah, so, yeah, I agree, I totally agree.
Just give me
with you,
some
'cause
facts here.
I was
Let's
in-
just
yeah.
say, hey,
So
there's some
the-
case law and this is.
back in Sturbridge, this happened.
Yeah. So the uniqueness of the lot and the topography of the lot has to be taken into account by the board. And that has to relate to, under 48, Section 10, that has to relate to the hardship that the people are experiencing. And so our argument with regard to the topography of the lot is that you take it in totality with the topography of the neighborhood, and that this is a unique situation because, again, it is the last lonely lot in this otherwise developed area, and they would their hardship would be financial and an inability to do anything.
Topography-wise, what do you mean? What is it with the topography that makes
Sure.
it different?
Topography is a combination of natural and structures. So the topography of the neighborhood is that they're all built out with structures on them. And this one is unique in the fact that in this area,
Isn't it the topography to the lot? That is
the
the
specific
hardship.
topography of this lot is that it's an unbuilt lot in a sea of otherwise built-out lots.
But characteristically, there's no weird hills or anything on the
No,
lot?
it's a nice build, it's a
Yeah.
nice lot. It's a nice lot for a structure, so it's not hilly or wet or, you know, or has any strange features to it. Other than the fact that, you know, in the combination with the history of the lot, and this quirk of 40A Section 6, that it got stuck in an otherwise topographical area of what would be a single-family neighborhood.
Yeah, I've driven by the lot fairly frequently, actually. I mean, it does stick out as a oddly, you know, there's an odd bunch of trees and a lot of houses. I guess my question is, would you be meeting the setback requirements of the prior zoning laws, the ones that, or with the
Nope,
current? You'd have to, okay.
We meet the structure would have to meet the current setbacks and all the other building and zoning laws of the town of Sutton. It's just the frontage and acreage variance that we're looking for.
Question.
Yes.
By accommodating the request, would we be creating a buildable non-conforming lot?
Yes.
It would be a it's still a non-conforming lot, correct, under the town definition of non-conforming lot. But the structure on it would be conforming.
Okay, but the lot itself would be,
The lot itself would be non-conforming, just like every lot in that neighborhood is non-conforming under today's bylaws. So anyone who wanted to do an addition or a garage, I'm sure garages and additions and everything from that neighborhood, they all have to deal with the fact that right now, under today's bylaws, they're non-conforming. Because, you know, now the
but
bylaw.
an existing, it has to do with, on existing structures, on non-conforming lots, it creates a special permit or a variance request when they create an additional non-conformance.
For those other lots,
For
correct?
those other lots,
Right, right, yep.
So it's a little bit different.
Can be, yes, it's definitely a different analysis.
Yeah,
Because most of those lots can avail themselves of a special permit process unless they're going further into the setbacks, in which case I think under the town bylaws. I was on the board in Uxbridge for 11 years. I just came off last year, so I've been in your seats before. But I think only if they're making an additional nonconformity, like into the setback, would they need a variance on those non-conforming lots.
So that's not really, it's apples and oranges.
Right, this is not a special permit
Right,
request,
right,
right? This is a straight-out variance, right?
Mike, you had a question?
So I will agree with everything you say. I think the lot can support a house. It has sewer and water. You'd be able to meet all the other setbacks,
Yes.
lot coverage. There's few other things.
Yep.
But I don't mean to hang my hat on it, but if this is the lot, just how, so I'm good with
Yeah,
it all. Like, I personally don't have any problem that this lot couldn't sustain a house and that it wouldn't be saleable and that it would be, but the thing is the Mass General Law, and let's just talk about with town council, because I haven't read through all of that, so I just have to understand what they are saying to our board. Because I personally don't have any issues with this being a lot. It's buildable, it's got
I don't
sewer,
either,
it's
but
water, it would be.
legally
Well,
we-
but that's what I'm getting at.
Right, legally.
Your
Yeah.
job,
Yep,
like
I
when
hear
you
you.
come, is to help
Sure.
us with that part.
That's right. So,
Okay,
so they haven't given any opinion on this variance petition. They were giving an opinion on whether or not the building inspector should issue a building permit because it was grandfathered. So we put that issue aside and we said, you know what, let's come to the zoning board and ask to use your discretion.
Do you wanna send it to town
But you
council?
could, but
No, that's not, I didn't say I personally did, I just.
Oh,
wanna
I think-
I'm
asking.
more
I think the
understand-
answer,
so-
I think if I could sit and, if I could
think we
put
can
on,
send
if I could put on
Oh,
town.
I just didn't
If
say I was,
yeah. If I could put on town council hat, I would say that it's, that you have the discretion to issue this.
That was
If-
something
if-
like,
if-
there you
if-
go,
if-
keep going.
If you make the findings that are required under 40A Section 10, the board definitely has the discretion to either grant
But I think-
So what are some of these
deny
findings?
this.
And I
So
don't
help
have
us-
40A10 in front of us.
Sure.
What in that is
Yep,
unique?
that's what lays out the variance standard, which is sort of which is broken down nicely, by the way, on your,
Help us,
on
layman,
your-
remember?
on your
This is what we're
application.
asking, see, now we're getting somewhere.
so on your
We're starting to be
application.
on the same page, so let's,
Yeah, so your application lays out the standard for section 10 perfectly.
Yeah.
Because they ask all the questions that need to be answered by you, and if you answer yes for each one of them, you have the discretion to issue the variance. So
So
if you,
even though.
if you answer number, so if you answer number 3, so when it says nature of relief, so nature of relief requested, we're asking for a variance. Then, if you go down to the findings that you need to make start with evidence to support the grant of variance. So that's the factual findings that you need to make in order to grant this. And so, so you have to say that there's a because of either the soil, shape, or topography that affect this land, that the owners are suffering a hardship. I'm summarizing a little bit, but, and so that was our first argument, that yes, they are suffering a hardship because of the nature of this neighborhood and the fact that it's the last.
I mean, the hardship unfortunately is self-inflicted in a way because they didn't know, or they didn't act within the 5-year when it was grandfathered. I mean, I'm in agreement with Mike, I mean, you know, it's just legally, I don't really see any way to do it. I mean, it's pretty much, we're taking a non-conforming lot, a non-buildable,
Well, I think it's
And-
non-buildable, right, and we're trying to make it
and
buildable.
you're trying to make it buildable, I mean,
Right.
if there is indeed legal cases, then, you know,
Well,
my opinion is, we deny it and you can duke it out in land court. I mean, that's
yeah.
unfortunately not a cheap way to go, but,
Or you
I mean-
or you could approve it and see if anybody appeals it,
Oh.
which I don't think they will. I don't think anybody will.
that's not really the way
I
it
guess
should
for me,
work.
I think asking town council their opinion as to the current state of
The
what-
request?
The
Yeah.
request, I think, might be prudent.
Sure, and then maybe if the framing of the question would be, do you have the discretion to do it, based on this petition?
I
think-
personally would agree to that.
I
Yeah,
think-
I'm fine with that,
That's
that's
my
why.
honest opinion. This is really tough. Think about it. This was a buildable lot that these people, and I don't wanna set precedents and I don't wanna create non-conforming lots. And I would want no more from town council, for myself, is for them to agree that what we were doing was legal. So if that's the way you felt comfortable, we asked it, and they would've come back.
I think
and-
if you frame the question
Cause,
just
because honestly,
as simply as that,
that's all it would take for me to be okay with this.
right.
Cause I think it's a fine lot in a fine neighborhood with all the necessities to meet a house lot.
And I think.
And I hate that hardship. I gotta make sure legally,
Sure.
you know,
Yep,
because this,
I-
and I've seen it before, and we, just help us with it, and
yeah,
There's some people who would like to speak,
sure,
so.
yep.
Sir, please state your name just for the record.
My name's Horace Achilles. I live at 49 Stone School Road. I've lived there since 1978. I have met the Lalondes, they're very nice people. I don't have a problem with there being a house there. The only problem I have is I was told there couldn't be a house there because it's wetlands. In the fall, in the spring of the year, there is a brook that runs out of that corner, right
Yeah.
through part of my land, into the next property's land.
Okay.
So I was just wondering, has it ever been perked to see if it?
Well, those are good questions, nothing that this board handles, so.
No, I know, but.
But, yeah, it's something they would probably have to deal with, you know, further on down the road if they were to get approval,
I hope they could put a house there, but
Yep.
I'm just concerned that that water's gonna end up
right?
ruining my
Your
land,
yard.
and I spend my life in my yard.
Yeah, we definitely have to comply with all the
Right.
other laws.
If it were to go through, sir, there'd be
And there'd
some
have
more
to be-
hurdles for them.
There'd have to be some engineering done to make
Right.
sure that the drainage is fine, so there wouldn't be.
In the spring and in the fall, there's a stream that runs there
Right.
constantly. It's not a big stream, but it's there, and it comes out of that corner.
so I believe that there's a requirement, there's an upland requirement of how much good land you have to have.
60%.
So I'm assuming, cause you've stated there's no other variances you'll need on this lot, cause if for some reason you start to go through boards, I'm
Yeah.
not gonna play engineer,
Right,
but he's
Oh.
bringing up a really good point.
Sure,
Yeah.
but we haven't spent the money on a full-blown engineering.
And just so that gentleman understands, the Sutton Conservation Commission will, there'll be a process that will
Yes.
determine all those areas, and this, we're just not our expertise, but I promise, there's a great board in town that if for some reason, and it was to make it to that point, and they go to conservation, I think they'll do a good job at reassuring you that it gets done correctly.
And we wouldn't be able to build without that.
Right.
So, that would be, that would be another hurdle that we'd have
Is
to.
it on GIS, is it a flagged wetland? Have you looked at the overlay?
I didn't see that, as a flagged wetland. Do you know?
Or not flagged, an engineer would have to flag it, but
Right.
is it
I know-
indicated on GIS?
I know the builder has had his own person go in there to check and see, and
But this is
he
Mr.
didn't
Lalone,
find
by the way.
any indication of wetlands. Cause that's one of the stipulations he wanted to make sure before we made this.
Right.
Yeah.
So it's
Was
been-
that it was a buildable lot and it wasn't wet, so he had his own guy, he must have hired an engineer or some, whoever he has, go in there and he got the okay from his guy that it was not wet or a problem, but.
So it's been informally
Oh.
looked at, but not formally, I guess is the answer.
Is there another question? Sir?
No, I'm Howard Kramer, I live at 6 Fox Run Road, and, so I would be, I think, as I hear clearly, I was the property that was sold off,
Okay.
to the previous owner, or the second owner of the land, of the house. I have the same concerns as Horace does. My property slopes kind of downward, but, with that, I'll use the term wetland, the backside of my property has, slowly eroded for the 20 years that I've lived there. So I would be concerned, just, where the house would be situated or oriented on the property itself, just to,
Well, they have
Okay.
a little diagram, I know it's not to scale, but that was submitted as to where the builder proposed, placing the house.
Is it this guy right here?
Right, right, yeah. So, but we would have to the whole plan would have to be properly engineered
Yeah.
and run by the other town boards. So if there were any concerns about wetlands or streams, they would be definitely handled by the building department and then conservation if there was conservation issues.
Okay.
This is sort of step one.
All right, thank you. Are there any more questions? So we're gonna, Lynn, you can contact town council for us and send this out to them and get their opinion, so.
So I guess just so I know how the question is gonna be framed, because if they give me a call and ask me what I was thinking.
Well, I mean, I think,
But
I think
would it be?
basically, the board wants to know whether or not they can issue variances to create a buildable lot.
yeah, I mean, it's gonna be
That's what
based
they're
upon
asking
your
for.
I think-
request right here is
I
what
think,
it's.
yeah, I think if you send along the petition and just ask them whether or not the board has the discretion to issue it, I guess is the answer.
I would say
You can-
create a buildable, non-conforming lot, right?
Right.
Because that's what we'd end up
That,
doing.
that's what the petition asks for, right?
Okay.
I mean, I would also like to ask whether there's a case for hardship here that the town council would agree with.
Sure, yep.
I mean,
I'm sure there's not because
I think-
I've looked
The
as much as
hardship
I
part
as
of
much as I could
48.
look. It's kind of,
I think that's what he's getting
it's
at.
trying to
Is
pull,
if
yeah, it's
there is-
a needle in a haystack.
in this law that we're referring to, you referred to it, because this is the one we're all looking at, the Mass General Law, Chapter 40A, 6. It clearly states that this is not a buildable lot. It's terrible, I don't agree with it, but
Right.
this is the law.
Yeah.
So we need town council to.
Actually, yeah, it says, not a buildable, not buildable as of right. But it doesn't,
Correct.
it doesn't say it's not,
Correct.
yeah,
Correct.
right.
Agree.
Not buildable as of right, but you could, if a board found for variance, then you could.
So this is a powerful thing for us to like to just go out on a limb and start to just not do what it says, so.
Yeah.
That's what we're looking for town council to just say, is that this board, like you said.
Yep.
Has the discretion to hear a case and create this lot.
Correct.
Okay.
Yep.
I mean, also how to interpret the term topography, I would be curious about.
Does section 10 apply to section 6?
Section 10, variance is sort of, variances are the last resort of a homeowner. They shouldn't be handed out like candy, and they shouldn't be used, they should be used sparingly. And
But acting under section, you're able to act.
Under section 10.
Legally, you're able to act under section 10 as it relates to a section 6
Correct, yes.
request.
Just to review the numbers again too, the
Well, we'll come back.
frontage needed would be 250 nowadays, and it has 222.12.
That's right.
And lot size needed nowadays would be 80,000, and currently it's 31,908.
Correct.
That was right, okay.
Be getting close on lot coverage too at that, right? 10%. 3,000 square feet. So, coming close.
Right.
On that as well.
He assured us.
Mhm.
There's no other variances for this lot.
Yeah. All right, so can entertain a motion to continue.
I'll make a
We
motion.
should hear back from, is there any other questions before? Okay.
I'd like to make a motion to continue.
I'll second that motion.
August 2nd, 7:30?
August 7th, 7:30.
7 or second?
Second.
I will
Second?
not be here.
Okay, great.
Thank you. Matters.
What?
Thank you for your time.
Thank
Alright.
you.
Thank you.
Just, I won't be here for that meeting, August 7th. I won't be able to make August 7th.
Second.
Second. Oh, second.
Second.
I can't make August 7th, but that doesn't matter.
I can't either, but now it doesn't matter.
Yeah, it really doesn't matter.
What's August 7th?
Thank you.
California.
No, you won't.
just were.
So,
Yeah.
From tonight, there will be an agenda that will be
Yeah.
posted, it will be online, and on the 7:30 here. So that'll be your form of notification, or you can call
Yeah.
my office. Okay. All right, you can do that as well.
Thank you.
Thank you.
All right, next on the agenda, we have, board reorganization. Bad night for Rich not to be here. Chairman and clerk, it looks like.
Yeah,
August 2nd.
7:30.
7:30.
You do a fantastic job, but Rich couldn't handle it.
Both jobs, you think Rich could do?
No, we won't give him both.
Does anybody else want to be clerk?
Jeez, don't everybody jump at his job at once.
I think you do a phenomenal job.
Thanks.
I second that.
Still think I'm at the beginning of the learning curve.
Well,
That's why you
keep
can't
going
let
then.
him
I
now.
gotta stick at it,
Can't-
yeah.
can't-
Okay.
Can't give it up now.
That's right.
You're just getting really good.
Rich, I think your leadership is excellent too, I think.
Uh-huh.
As well.
Yeah, that's just
This
because
is
you
a
guys
lot
don't
of
wanna do it,
progress.
but thank you.
Oh, no, I just,
I really do believe that.
I as well.
I
And I've been here a
believe
while,
your
and
leadership
I think this is the third time I'm gonna nominate you as the chair.
Sorry, Lynn.
I'll second.
This is Lynn's favorite meeting of
So I
the,
said
of the
it. I
year.
nominate-
She likes to think that we're gonna really reorganize, but we
Yeah.
don't. So we'll entertain a motion to
Keep the
Keep
organization.
it the way it is.
keep it the way it is. All those in favor?
Aye.
All right, we've got some meeting minutes from June. If everybody's had a minute to look at. Entertain a motion to accept these minutes from June as they are prepared in front of us.
I'll make a motion.
Second on that.
Second.
All those in favor? Aye. All right, we can do a work session on our earlier application. So I'll entertain a motion to open a work session on the petition of Alicia Reed.
Make a motion to open a work session.
Oh, did I get a second on that? All those in favor?
Aye.
So the applicant is seeking a permit to build a farmer's porch on the front of their house. I'll entertain a motion, if someone would like to make one.
I'll make a motion to approve special permit for the construction of a front farmer's porch.
I'll second that motion.
Any discussion? Pretty straightforward.
Do we make mention any,
The plan,
For,
as shown on the plan.
as shown on the
Right,
plan?
as-
And then John just uses that as his, yep,
give or take an inch, right?
give it, take an inch.
Couple inches.
Yeah, I mean, it seems like a pretty,
Standard.
I drove by the house, it's gonna add to the quality.
I was gonna say, seems like an
Yeah.
improvement,
It's a
right?
natural addition to the house.
Yep, I agree.
Actually, the house right next door years back did the same thing. when it was
Yep.
on the board.
It's very in keeping with the neighborhood, it's
Okay, we've got a motion and a second. All those in favor of granting the special permit? Aye.
Aye.
Any opposed? The ayes have it. Do you have that all written up? I'll entertain a motion to,
It's coming along. This is drawn up.
or entertain a motion to adjourn?
I'll make a
What site visit reports from Graves, this is all up on Leland Hill?
Yeah, that's just stuff that
Just-
came in the mail, correspondence, in case you wanted to, just review. Those are our,
Anybody-
from our engineers.
I think that
Is there
we had
anything that-
asked, I think we had asked for that as part of.
Right, but is there anything we should be discussing in them? I mean, this stuff's gonna come at us, I know it is. Remember the last meeting, bond, done, outta here? Well, we're getting
Well,
Graves
I-
Engineering, these are the site reports that,
I can't see anything about
oh, yeah,
they're just reports.
okay, I'll just
That's all.
throw them that.
Yeah.
I just didn't know, so,
Yep.
would somebody bring it to our
John
attention?
is working with them on that, so John is overseeing it as well.
So if there's anything
If
that
there's
is,
anything that you read in there that is concerning, I would give John a call.
okay,
And then maybe we can bring, if there is an issue, we can bring it back to the board.
okay, right, I mean, we just should be paying attention near the end of we're not used to this. Planning board
Right.
usually does all this type of stuff, but
Right,
the town will end up with a public roadway that we're all responsible as taxpayers. So
Right.
we just don't lose track of this, cause we've gone through a few members over time and just, there's things to just make sure the i's got dotted and the t's got crossed. And there's paperwork trails. That's it.
All right,
Motion to adjourn.
we had a second on that?
second.
All those in favor?
Aye.
See you next month.